Hello and welcome back to Inside the Contract. We are still on season 1. This is episode number 5. Today's topic is writing contractual letters. Precision, power, and legal protection. In this episode, we move from entitlement theory to daily practice. We focus on contractual letters, the documents that preserve rights, trigger procedures, and often decide disputes long before a DAAB or a tribunal is involved. Okay? Strong letters win claims, weak letters kill them. Under FIDIC, your letters are your legal ammunition. The first documents DAABs, arbitrators, and courts look at. Today, we go far beyond formatting. You will learn how to construct letters that shape the narrative, anchor your entitlement, and place the burden of proof exactly where it belongs. Under FIDIC 2017, letters are essential because, number one, notices create rights. Examples, clause 20.2.1, 28-day notice, or clause 1.3, the formal communication. 2. Letters preserve entitlement. Late or non-compliant notices are a frequent basis for employers to resist entitlement, and decision makers often scrutinize notice compliance closely. 3. Letters build the claim record. Arbitrators rely heavily on contemporaneous documents, not retrospective explanations. Number 4. Letters protect you when the engineer is biased. Where the engineer is required to make a determination under subclause 3.7, the engineer must act neutrally. Your letters help ensure the process is properly engaged. Number 5. Letters communicate discipline. Professionally written letters influence the engineer's credibility assessment of your claims. A well-written letter is not paperwork, it's a legal strategy. Under clause 1.3, formal communication must be written, delivered, and or transmitted to the address or agreed electronic system stated in the contract data or as subsequently notified under the contract. They must be sent to the correct party, referencing contract headers and numbering, trackable, retrievable in disputes. Why this matters? If a letter isn't sent per clause 1.3, if communications do not comply with clause 1.3 or subclause 1.3, the other party may argue that they were not valid contractual notices or were not properly received, which can materially weaken entitlement. Okay? The tone of the letter: professional, clear, and unemotional. The 3 biggest tone mistakes: emotional language, aggressive accusations, long stories without facts. Professional tone phrases, examples: we draw your attention to subclause such and such, or we respectfully request confirmation on such and such matter, or as per the contract, subclause such and such, or we hereby notify the employer of such and such event, or please find attached evidence supporting such and such event. You need to avoid phrases like, we are frustrated, you are delaying us, this is unfair. Tone determines credibility, and credibility determines entitlement. Please keep that in mind. So, what is the structure of a legally strong contractual letter? Here is the 8-element format used by top-tier contract managers everywhere, especially when dealing with making grounds for future claims. Number one, clear subject line. Examples. Notice under subclause 20.2.1, late approval of shop drawings, shop drawing number 241. Or request for engineer's instruction, subclause 13.1, change in location of medium voltage panels. 2. Purpose. For example, one sentence. This letter serves as a notice under subclause 20.2.1 regarding delayed IFC drawings for Zone C. 3. Chronology of facts. Use dates, logs, and references. Examples. IFC drawings were contractually due on 1st of June, received on 19th of June. Critical path activity number MEP 027 delayed accordingly. Something along those lines. Number 4, contractual basis. Quote exact clauses. Cite the clauses that match the event. Example, delayed information and or instructions. Access, variations, DOT entitlement under 8.5. and claims procedure under 20.2. Of course, these clause numbers or as amended by the particular conditions. Number 5, cause and effect demonstration. You need to show linkage. The late approval prevented commencement of activity A145, delaying slab casting by 12 days. Number 6, request for action. Example, we request determination under 3.7 if the matter is for determination, for example. Or we request instruction under 13.1. Or we request acknowledgement of this notice. Number 7, attachments. List evidence, drawing register, progress photos, emails, meeting minutes, time impact analysis extract, if applicable or available. Number 8, professional closing. It has to be short and neutral, okay? See, let's look at, how the some of the legal standards and best practices, how it affect your letter writing. We draw from some legal cases and some standards. One case here under the UK Technology and Construction Court, TCC. So just again, while governing law differs by project, the reported court decisions, particularly in this case, the UK TCC, often highlighted the practical value of clear contemporaneous records, early notice, and correct contractual pathways. Several cases were listed under this court. I'm going to refrain from naming these cases for confidentiality purposes, but the purpose is clear. Other than this legal standard, for example, some other best practices like the SCL protocol and the AAC International. The SCL protocol guides your letter to be early, clear, detailed, linked to records. The AAC International recommends consistent logs, objective data, written communication trail. However, keep in mind that SCL protocol and AAC protocol are, recommended practices, can help shape good record keeping and persuasive correspondence. But they are guidance and must be applied consistently with the contract, okay? Another arbitration patterns that have been reported and especially in the GCC arbitral tribunals. In GCC disputes, tribunals commonly focus on whether the correspondence is cross-referenced, timely, supported by contemporaneous records, and aligned with program updates. Of course, all of this subject to the governing law and the C2 arbitration. But again, the message is clear, and I'm being disciplined and accurate in your record keeping, especially in letters. Okay, so let's look at some of the common project patterns, which, give some really powerful lessons. Case study number 1, some major projects in Qatar. Contractor complained verbally for weeks. Letters they sent were vague, something like, "We are facing delay due to design." The other party argued these letters were informational updates, not contractual notices, creating serious risk to the EOT case. Lesson: letters must be concise and clear. Another major project here in KSA, which the contractor here actually did the opposite and was accurate. Contractor issued structured letters, referencing 20.2.1, identifying delay events, attaching evidence each time, maintaining discipline. This discipline strengthens the EOT on cost arguments and improves enforceability. The lesson: precision means or equals entitlement. Another mega project here in KSA. Contractor submitted emotional letters with dramatic wording. Engineer argued tone indicated blame and not contractual notification. Decision makers may treat emotional non-clause based letters as complaints rather than formal notices under the relevant clause. Okay, keep that in mind. Another major Dubai project. Contractor issued letters in perfect structure, but sent them to the wrong official email. Imagine that, not in accordance with clause 1.3. Employer denied receipt. So misdelivery can allow the other party to dispute receipt or validity under subclause 1.3, weakening the claim. Imagine how sad will that be, okay? So what are the golden rules for writing contractual letters? 1, where possible, reference the relevant subclause or clauses. 2, always use contract language. Always cite dates and evidence. Keep paragraphs short. Keep your claim and delay registers aligned. Maintain consistency across letters. Avoid emotional tone. Ensure compliance with clause 1.3 delivery method. Train site and engineering teams to provide evidence for your letters. Okay? So it is probably a good idea to have some essential templates on hand, which every contractor should use. Some of the high value templates I recommend. When first, notice under 20.2.1. 2, request for engineer instruction. 3, disagreement and or reservation of rights letter. 3, reference to clause 3.7. Of course, depending on the case. Here, for example, there will be 2 options. Option 1, request for engineer's agreement / determination. Option 2, notice of disagreement with a proposed determination or request to proceed to determination. Number 4, late approval notification. Number 5, late drawing notification. Number 6, site access delay notification. Number 7, authority approval delay log plus letter. Number 8, formal follow-up notice. Okay, having these templates ensures consistency, which is a key defense in disputes. Okay, so by this we come to the closing of episode number 5. And remember, contracts are won and lost through letters, not meetings. Okay? Master this skill and you control the contractual narrative. Protect your rights and prevent small issues from becoming major disputes. Okay, please keep that in mind. Okay, this concludes episode number 5. In the next episode, number 6, we will navigate another misunderstood milestone, which is taken over versus substantial completion. Okay, thank you for watching, and I will see you in the next episode.